My name is Ernie Brown, and I've been a construction lawyer in California for over 30 years. I'm going to give you 7 common mistakes that contractors have made that have resulted in them losing their license. Your license is one of your most important assets. You've worked hard for it, and it's your livelihood. In addition, if you lose your license during the course of an active project, you won't be paid for what you've done, and you may have to disgorge all what you've been paid up to that time back to the owner. Finally, you may find yourself in disciplinary trouble with the license board, and worst case, you may not be able to get your license back at all. So these are the 7. First, change of address. Sounds so simple. But if you move, the license board, your bonding company, and your workers' compensation company may be sending you notices you never get. And if you simply do a broad request from the post office for forwarding, that will expire probably long before these notices come to you. And again, if you don't know that the suspension, a problem with your bond, or a problem with your workers' comp, you won't be able to react to it, and you'll have a license suspension and not even know it. The second thing is compliant contracts. Almost all the contracts that we see in this office that come in on disputed cases have some flaw or absence of clauses that are required to be in the contract. One of the most common and simple errors, and very dangerous one, is to not put the name of the licensed entity on your contract. If it says Inc. or LLC or partnership, but that's not what it says on your license, on the Contractors License Board website, then you're contracting without a license. And the other side will spot that, and they'll say no payment, disgorgement, and you're subject to disciplinary action for acting as an unlicensed contractor. Those are especially significant in pool cases or roofing, or for that matter, any type of home renovation contract. There are also limits on how much of a deposit you can take. And if you violate those things, you might find yourself suspended by the license board because of disciplinary action. The next one is your responsible managing employee, your responsible managing officer. If one of those people leaves or dies or gets sick, is not capable of supervising the work, you need to immediately replace them. And don't wait till the last minute. It's a very limited period of time to do that. You can get extensions if you're on top of it, but you have to know the rules. If you don't get them, you are going to be suspended. If you wait till the last minute, the person that you suggest should be the new person may have a problem with an unsatisfied judgment or a criminal conviction or some other problem that means that they won't be immediately accepted as your replacement, and therefore you will end up being suspended. Very important. Now, this next area has to do with some very recent changes in the California labor law. We had a case for a long time, which is called the Borello case, and it told us pretty much a bunch of criteria that says whether or not somebody is an employee or an independent contractor, and those rules were fairly well settled. In 2018, a case called Dynamex came along. The Supreme Court of California made it very, very hard to show that somebody was an independent contractor and not an employee. The construction industry got some relief from the Dynamex case and the ABC test in new legislation that's been passed, which is AB 5, which starts into effect January 1st of 2020. But that is also a statute that presented some specific risks. Now, how does that affect your license? If you are a subcontractor and you hire people, pay them under the table, or you consider your superintendent to be an independent contractor, or for other reasons you're underreporting your payroll, you are automatically suspended under the license rules. Specifically, under a case called Wright versus Isaac, 2008 case, from the moment you underreport to your workers' compensation carrier your payroll or your estimate, they will consider you to be suspended. And who will find that out? The license board will find it out, and an owner will find it out because they will check your payroll or your certified payroll against the people who are actually on the job, and then they will be able to say you're not licensed, they don't have to pay you, and you have to disgorge everything that you've been given. Very serious problem. In addition, a lot of people say, well, I'm a small operator, I'm not subject to workers' comp. There are certain folks, though, that can't claim that exemption, that often don't know it. Roofing contractors, C-39, specifically cannot claim exemption from workers' comp. It's a very dangerous area of construction. They have to have workers' comp coverage. Same thing with regard to if you have an RME. It means you have a responsible managing employee. You have at least one employee. You have to have workers' comp insurance. The final one is a simple one as well. Have a business license. Or if you're an individual, contractor have your doing business, your DBA, in the state and the county location where you're doing the work. So you can file a lawsuit if you need it. But importantly, now under AB 5, starting at the beginning of 2020, you have to have a business license in the community to be considered an independent contractor and have that exemption under the AB 5 rule. Very important to have a business license, even more than before. Above all, realize that if you have a license problem or you think you have a license problem, get professional help from a construction lawyer or a licensed lawyer, because you have a very narrow set of criteria to be able to get relief and very limited time periods to do so. And if you don't, then again, you snooze, you lose, and your license will be lost.